Hello, I'm Gaurav Sharma from Hitbullseye.com and welcome to this lecture in which we shall cover Indian Judiciary. Now the basic purpose and the function of Indian Judiciary is to adjudicate upon laws which are made by the Indian legislature. Now if we compare Indian legislature executive with judiciary, we shall see that there are a few differences. Firstly, we have an integrated judiciary. Now what do we mean by integrated? See, when we see the Indian executive, that is, we have a union or a central government and we have state governments. But on the other hand, with respect to judiciary, we have an apex court, that is the Supreme Court of India, and secondly, we have subordinate courts which are under the Supreme Court, that is high courts, and again subordinate courts. Whereas with respect to judicial legislature or executive, there is a central government which is independent, and there are state governments which are independent in running that state. Now we shall study the Supreme Court or the apex court of India. The composition of Supreme Court is as such. There are 31 judges which has been fixed after 2008. The Chief Justice of India is included in those 31 judges. So there is a Chief Justice of India and 30 more Supreme Court judges. These Supreme Court judges are appointed through a collegium system. Now this collegium system includes CJI plus 4 senior most judges. So 1 plus 4, that is a collegium of 5 judges. Now there are certain qualifications which are required to become a Supreme Court judge. Now firstly, of course, he should be a citizen of India, and secondly, either he should have been a judge of a high court for 5 years, or an advocate of a high court or a Supreme Court for 10 years, or very important, a distinguished jurist. That is, he should be a distinguished jurist in the eyes of the president. Now all these appointments of judges, it is run by the president, but of course the names are suggested by the collegium. Now with respect to the tenure of Supreme Court judges, the constitution does not fix any tenure, but there are certain provisions which are related to it. Firstly, the Supreme Court judge stays in office till he has attained an age of 65 years. Secondly, moreover, he can also resign any time by giving his resignation to the President of India. And thirdly, he can be removed by the Parliament. Now the emoluments are charged upon. That means that they cannot be voted upon by the Parliament. Now the procedure of removal of judges is such that there are 2 grounds which have been established. First, incapacity, and second is proved misbehavior. Now this proved misbehavior means that the Parliament is empowered to remove the judges who have done something which is against the norm of the Constitution. Now the procedure for the removal is as such. The motion of removal of judge can be initiated in either house, that is Lok Sabha or Rajya Sabha. To be initiated in Lok Sabha, the motion needs to be signed by 100 members, and in case of Rajya Sabha it is 50 member of parliament. Now this motion is entertained or accepted by the speaker or the chairman of in case of Rajya Sabha. Now if this motion is accepted and is passed, now both of the houses need to pass this with special majority. That means the majority of the total membership of the house plus a majority of no less than 2/3 of the members present and voting. So once the motion has been passed in both the houses through special majority, this motion goes to the president, and the president issues an order removing the judge. We shall see what the powers of Supreme Court are. Now the first power is original jurisdiction, which means that the Supreme Court is empowered to hear and decide upon these issues in the first instance. Now there are 3 main types which are covered under this. First is center versus states, that is Government of India versus Government of the states. And then there is center plus any other state, one or more states, versus more states, like center along with state versus other states. And then there are of course disputes between 2 or more states. This is covered in the original jurisdiction. Now Article 32 it covers the writ jurisdiction. There are 5 writs which we had covered in subsequent lectures. Now these 5 writs are mandamus, certiorari, quo warranto, prohibition and habeas corpus. Again, the third bar is appellate jurisdiction. Appellate jurisdiction means that if an aggrieved person thinks that justice has not been delivered to him either by the subordinate courts or even the High Court, so he has the power, he is empowered to go to the Supreme Court for seeking justice. Supreme Court is also a court of appeal. Now the next power is the advisory jurisdiction of the Supreme Court of India. Now this is also covered with Article 143 of Constitution of India. It is the power of the President to seek advice from Supreme Court. Now there are 2 conditions which have been specified in the Constitution. First, in case of a law or any issue which is of public importance, and secondly, dispute arising of because of any pre-constitution treaty, that is if we had some treaty before the constitution came into force. The most important thing in this is that the advice which is given by the Supreme Court is not binding on the President. The next is the Supreme Court is also a court of record. That is, the pronouncements or the orders which are given by the Supreme Court can be used as a means or as a rationale for future decisions. Now one of the most important provisions is the judicial review or the power of judicial review. Now judicial review primarily means that the Supreme Court is empowered to adjudicate on the laws which have been made by the legislature. If the Supreme Court feels that the law which has been made by the legislature will not pass through the will be against the virtues of the Constitution of India, then it can term this law as ultra vires, that is against the Constitution. So this power of judicial review is a part of the basic structure of the Constitution. Now this brings us to the second level of hierarchy, that is the High Courts. Now not every state has a High Court, but there are certain joint High Courts as well. Like states of Punjab and Haryana and the Union Territory of Chandigarh, they have a combined or a joint court. Similarly, Goa and Maharashtra, Puducherry and Madras Tamil Nadu have a single High Court, and so on. The composition as such varies from state to state. As of now, there are 24 High Courts. The appointment is done again similarly by the collegium system. But in case the High Court, a High Court judge has to be appointed, then the collegium system also takes the advice of the Chief Justice of that High Court. Now the qualifications of High Court judge are as such: he should be a citizen of India, and secondly, either he should have held a judicial post for 10 years or he should be an advocate of High Court for 10 years. So there is no provision of an eminent jurist in the case of High Courts. Of course, the tenure again is not specified by the Constitution, but there are certain provisions which relate to this. The age of this High Court judge should be 62 years. The maximum age is 62 years, and again, he can resign anytime. He can be removed by the Parliament, or if he is elevated to the post of Chief Justice of India or a Supreme Court judge, then he can automatically be removed. He is removed from the High Court. The emoluments or the salaries is charged upon, and thus it cannot be voted upon by the Parliament. The removal of judges is similar to the case of Supreme Court judges. That is, they can be removed through a motion which can be introduced in either house. Again, signatures are required, and after the motion has been passed in both the houses through special majority, the President orders seeking the removal of that judge. Now let's review the powers of the High Court. Again, original jurisdiction, that is, it is the power of the High Court to hear such cases in the first instance. Again, they have a writ jurisdiction similar to the Supreme Court. Again, 5 writs. That's again a court of appeal with respect to the subordinate courts, that is, lower courts under the High Court. And of course, it has control over the subordinate courts. It again is also a court of record, that is, its order, its pronouncements, its judgments can be used for future orders. And again, it of course has the power of judicial review, which is synchronous with the power of the judicial review. Now, the subordinate courts are the third level of hierarchy. There are district courts and session courts. The difference between them is the district courts review or take decisions on civil matters and session on criminal matters. Now just let's have a review on the questions that were asked in the previous years. Firstly, the judicial review in the Indian Constitution is based upon, the options are procedure established by law, due process of law, rule of law, precedents and conventions. Now, the judicial review is a part of basic structure of the Indian Constitution, and as such it is advocated by the procedure established by law. Now, this brings us to the writs. There was a question which was asked on this. Which of the following writs actually means we command? Article 32, that is right to constitutional remedies, empowers the High Court and the Supreme Court to issue writs for the protection of fundamental rights of individuals. Habeas corpus means you can have the body. Where is the body? Quo warranto means by what authority? Mandamus means we command. Certiorari means to certify. And the fifth one is prohibition, that is to stop misuse of a public institution. Now the next question is that the judge of an High Court can be removed from the office during his tenure by, similar to the removal process. The governor cannot do so. The president on the basis of resolution passed by the parliament by 2/3 of majority. This is the right answer, and these are not so. So this brings us to the end of this lecture. In this lecture we have studied the Indian judiciary, its compositions, its functions, powers, and in the subsequent lectures we shall also shed some light on other political aspects. Till then, good luck, work hard and hit the bullseye.